bring on board folks from PDC Energy for an operator perspective on pooling and spacing. Hearings Manager Amaro, if you want to go ahead and get the participants to the fore, that would be great.
We'll do that, yes.
Good morning.
All right, great. I see 4 of you, and Ms. Loper has unmuted, so it looks like you're going to start us off.
I am. Good morning. While I'm talking, I'm going to try to share my screen, so I'll try to do this as fast as I can. Good morning. Thank you sincerely for the opportunity to present to you today. I think that the staff and the presentations this morning have laid a really great foundation for what we would like to share with you. And I think really that is the operator perspective of this, what it looks like on our side. And I have with me today several of our internal experts. I have Dana Strunk, who manages our planning and development. I have Paul Wisnand, who's our director of land. I have Tyler Sims, who's our land advisor and one of our resident pooling experts. And I have myself, least important person, but I manage our stakeholder relations department, which includes government relations and community relations. Just briefly, a little bit of context about PDC. We are the largest Colorado-based oil and gas operator. We employ about 450 employees here in Colorado between our 2 offices, our field office in Evans, and then our headquarters in Denver. We've been headquartered here since 1999, and we've been operating here since we've been headquartered here since 2009, and we've been operating here since 1999. So we've got a lot of experience in the basin, and we truly consider ourselves to be a Colorado company with Colorado values. And this topic, which I think really gets to the nexus of the interaction between community and operations, is really who we are. We value the relationships, we value the transparency, we value the two-way conversation. And so this topic, I think, really hits on a lot of that. And so we're eager to share with you how we approach this and what this looks like on our side. So I'll turn it over to Dana to give you a little bit more context, and then we'll welcome questions during the presentation, after the presentation, whatever makes the most sense. We're happy to answer any you may have.
Great, thank you.
All right, thank you, Courtney. As she said, my name is Dana Strunk. I'm the Planning and Development Manager for the Wattenberg asset at PDC. Appreciate your time today. What I thought might help first is just to give you a high-level overview of our development strategy, and that might help paint the picture of why spacing and pooling is important before I hand it off to Paul to go start into the details. So what we're showing here on the right is PDC's current acreage map. So as Courtney said, this is 20 years in the making, and it's really taken off in the last 10 years with the advent of horizontal drilling. With that, we've been really making an effort through trades and mergers and acquisitions to create a contiguous acreage position. So we have about 180,000 net acres now, and we're operating 2,800 wells, and over half of those are horizontal wells. And we're adding to that number every day with 1 drilling rig and 1 completion crew. So again, the goal is to consolidate that yellow, and the point of that being is that we really want to get in there, develop an entire acreage area at once, be able to efficiently and methodically drill through our minerals. And in doing that, we can limit and reduce our surface disturbance, both in putting multiple wells on one surface location and also plugging and reclaiming some of our vertical wells in the area. We also try to create alignment with our stakeholders, such as our local governments and the communities that we're working in. And we keep our top priorities as health, safety, and the environment. So very important for us to be able to get in there and develop the areas in a methodical fashion. So if we go to the next slide, you're probably wondering what that really has to do with spacing and pooling. And I can talk about planning and development all day. I'd love to do that in a different venue, but I just want you guys to understand that planning is really an intricate process between a lot of different groups. It's geology, engineering, and land and EHS. And what we're trying to do is balance the subsurface development with our surface limitations. So you can kind of think of it as a big puzzle. You know, we've got all of this acreage and we're trying to come in here and create these puzzle pieces and try to understand where we can develop and how we can do that in the best way. And that is what I'm trying to depict here. So I've kind of created this cartoon example development here. It's never this easy, but what I'm trying to show here is you've got 4 sets of 2-mile wells. So in the southern portion, you can see that 2 of these sets, we were able to find a surface location that can accommodate for both of those sets of wells. And then in the northern portion, we've got a different pad for each of those wells. And then we come in here and we think about spacing. And I've depicted those into the different color boxes. So you can see on the southern part, we've got 1 spacing unit with those 2 2-mile developments in blue. And in the northern side, you have in green and yellow 2 different spacing and eventually pooling units. So what you can take away here is that each unit can be different sizes, different shapes, different number of leases, different numbers of wells. And you could see in the green spacing unit, you probably have some working interest partners because the northern half of section 28 is white, assuming that our acreage is in yellow. So a lot of different opportunities to do, you know, there'll be different considerations in each of these units. But what I want you to kind of have this picture in mind as we dive into the details of this is where we start. This is why we need the spacing and pooling. And so I guess with that, I will hand it off to Paul.
Thank you, Dana. When it comes to spacing and pooling, those are processes that are really subsurface in nature. And before we dive into really the meat and potatoes of what we experience related to those 2 efforts, I need to lay some of the groundwork, which I want to commend Mr. Peskin for his presentation because I think that really helps in some of the groundwork. So early oil and gas development was governed by what was called rule of capture. And rule of capture was, in essence, if you drilled a well and you brought that oil and gas to the surface, it was yours, regardless of the subsurface contributions of the production. So what you ended up having was a furious race to locate wells at the surface, typically as close to boundary lines as possible initially, so that you could drill and produce as much of that oil and gas down in that subsurface pool. That led to what is represented here in a picture on the right, which was pretty early in my career. And that led to the necessity of spacing. So this is not what we want to do. We need efficient and effective development of the natural resource. And spacing was the first step to really create what would be 2 efforts, spacing and pooling, that really go hand in glove. But spacing supported that efficient development of oil and gas. So creating a better distance between these oil wells so that it was a more efficient development of the resource. It also protected that unauthorized drainage of those offset owners. And then it also reduced the impact on the surface. The pooling side came through when we recognized that as wells were drilled, we recognized that that production was coming from potentially more than the tract that it was drilled on. And so we needed to proportionally allocate the revenue or the royalties to those tracts that we were believing to be producing into that well. So it integrates, pooling integrates those tracts, whether they're large or small, into a pooled unit. It protects those small tract owners. So if spacing were to prevent a small tract owner from locating a well because they're not able to create the separation from a boundary line to place their well, they are then able to be pooled into an adjacent well that they are theoretically contributing to the production in that well. And spacing and pooling, again, really go hand in glove to create a more methodical, efficient, and effective development of oil and gas. Next slide. So this is really the meat and potatoes, as I referenced, and I'll be handing it off to Tyler. But again, we've got a spacing process, and then we've got a pooling process, and those two things have some commonality, some overlap, but generally kind of run in their own separate timeline. So I'll hand it off to Tyler.
Thanks, Paul, and good morning, Commission and staff. And to carry on with Paul's explanation here, I like to think of this as, we started with Dana's stepping stones of the development strategy and the outline, and then we moved down these stepping stones through spacing that get us to those final steps of when we get around to the need to pool or not. So to be able to make those steps, we need to start, again, kind of like going back to the rule of capture, but here we're going to start with title. The building our title and understanding what the title is telling us is how we get around to the eventual understanding and how we ensure that we're notifying the right parties. And this is an involved and detailed and time-consuming process. And there's a lot of information on this slide. I'm going to walk through this timeline pretty quickly so we can move on to the pooling aspect, but it's important to start with this abstract of title. When we start here, we don't always know who all may be an owner in a unit. So we have to start with building this abstract. This abstract, many of us have leased an apartment, or you've bought a house and you've signed a warranty deed, or you've signed a lease. Your lease may be 3 or 4 pages. Maybe you've signed a mortgage with that. You've released a mortgage and bought a new house. All of these are an instrument. So it's important to think of the volume that this information is. This one deed is one instrument, maybe 1 page, but your lease could be 5 is one instrument. So we build this database of information within, say, one section that could be anywhere from 2,000 instruments to upwards of 30,000 we've recently seen. Every year there's more transactions, there's more things happening, and property rights continue to be traded and sold, and mineral rights. And so we build this huge database of instruments that, what do we do with this? Why are we doing this? Why do we need this? We need to understand throughout history how we get to today, who is the proper owner of a mineral interest, and how do we make sure we've notified the right party? So we start with building this abstract that could take a little less than 3 months. It's taken more than 3 months. We build this information that eventually we're going to hand off to a title attorney to take these next steps and really understand and get more solid on who the parties are. Again, making sure we're notifying the right people. But what I really want to highlight here is that within the context of our abstract and our leasing process, this is our first opportunity to identify an unleased party and to be able to start that dialogue with them. This is when PDC creates our form letter and our lease offer, and we attach a lease to it, and we send it out to whomever we may have identified in this abstract process that we think may not be subject to an oil and gas lease already. And so we start this process here and kick it off.
I'd love to jump in there because referencing back to your question, Commissioner McGowan, regarding owners and the status of owners, and Commissioner Gonzalez, your response very much appreciated. The status and label associated with an owner can be very confusing because it can depend upon where they're at in the process. I absolutely can get lost sometimes in where we are at with a specific owner. But the title opinion is really the starting place for defining who those working interest owners are, those other operators, who is unleased, who they are, and really from a subsurface perspective, this is our definitive start related to ownership. And as we move forward, we may see a working interest owner non-consent in the well, and that can change their label. We may see an unleased owner become leased, whether it's by PDC or another third party. They then are a royalty interest owner subject to a working interest owner that could consent or non-consent to the wells. So I appreciate that conversation because it is a sometimes confusing discussion.
So thank you, Paul, for that clarity. And I'm going to take it back a step. And as we move to the title opinion portion of this process on our timeline, what our title opinion does is our title attorney then takes the abstract of title, this plethora of instruments, and they try to consolidate it into information that someone like me, a landman, can actually absorb and utilize to ensure that, again, we are getting more certainty and we're dialing in on who are the parties that are involved, what is their status, as Paul mentioned. Are they working interest owners who have their interest by virtue of having that lease agreement? Are they a royalty interest owner, again, by virtue of having a lease in place? Or are they an unleased mineral interest owner? And we've confirmed that a little bit more so with this confirmation of title from a title attorney. The title opinion is invaluable as it also helps give us a kind of a snapshot of what risk may be out there and things that we need to be working through in order to make sure that we're protecting all the parties who are involved in and have ownership within this boundary, this spacing unit that we intend to develop. And again, another time-consuming process can take anywhere from 6 months to 12 months. We've had several that take longer than this because of, again, how many instruments are involved, the owners, and how complicated it may be. And where I like to kind of give an explanation of the complications we find here is that in our abstract, like I mentioned earlier, we may identify an unleased party. And we go and we make that first contact. We send out our form and we try to make contact. The title opinion helps give us that additional step where maybe in the abstract we knew that someone kind of fell off of the records in, say, 1960. We don't see them active again for decades. We don't see their name in the record for decades. The title attorney can take that next step and oftentimes help us bridge the gap to figure out what happened to that party. And we may find out that they may have since been deceased, but they maybe died in another state. They can help us bridge that gap and see, hey, we found a probate in another state. We believe that this decedent left two heirs, these two sisters, that here's what they're, here's where they are, here's their address, here's who you need to go ahead and try to reach out to because we think this other party is no longer here. So it helps us, again, get an additional touch point to figure out where do we go from here with making sure we've identified all the proper parties. So we take our title information, we take all this information and we move into, for spacing, we move into the preparation to submit the application. And quickly, this is just providing a summary of that ownership information that we've accumulated, description of the lands we intend to space, again, reflecting, like Dana mentioned, say that green box that we're going to space that green box for our development. And we also start to do the research on the existing spacing orders as those may or may not be implicated in what our plans are going forward and how we need to accommodate for those existing orders. So we package that together and we move from the application into our notification portion of the spacing process. And in this process, we're providing notice to the working interest owners and our unleased mineral interest owners. And again, this is a benefit for the operators where we're getting yet another touch point out there to identify and make contact with unleased parties. As we continue to work through this is an ongoing, I feel like we should have had another timeline at the bottom that just shows PDC's leasing process because it's an ongoing process throughout this slide and as we move through pooling. And this is just another opportunity for us to work through that.
Yeah, and once those notifications go out, there's really a bullet point that's not shown in between notifications and spacing review, which is our engagement with those working interest owners, those other operators, if they are protesting our spacing application. And it can come about in a number of different ways or different reasons. It could be that they had other plans develop. It may not fit with their business plan or the timing of their business plan. There are so many different reasons, but from a spacing perspective, typically those disputes are with another third-party operator that we're trying to work through. And generally, the spacing process is probably a little bit more mechanical and administrative from a mineral owner perspective, whereas the pooling process, just as Tyler referenced, we're able to have probably more of a substantial touch point with those owners, especially those unleased owners when we're going through that pooling process.
So to take it from 4 to 5 on this slide and kind of wrap up the spacing piece of it from our perspective, again, we're just completing these nuts and bolts of this. We provided the notice. We're working through this process. The final piece of it for us is providing our technical testimony from multiple disciplines that go to the commission for review. And this is where I feel it gets a little bit more collaborative if we have follow-up questions from staff and we need to clarify certain things. And we, as Paul mentioned, we're working with maybe another working interest party, again, to help be collaborative with them to work forward with what's a spacing application that we think we can get approved that's going to be beneficial for everyone involved. And so eventually, hopefully, from here we get the spacing order approved and we can move on to the pooling process. Thank you, Courtney. So before I get down all those steps to pooling, again, we have to back up and start with this title opinion. And we already have this developed. We already have it in hand. We've already been working from it. But again, it's that document that helped to get us some clarity on who the parties are. And so we use this document to move to the Rule 506 election letters. You'll hear election letters. You'll hear well proposals is what we tend to call them internally. And this is that notice that goes out of the operator. We're intending to go ahead and start a development. We've got wells planned from Dana's team. We know where we intended to, what our spacing is going to be. This is the next step. We're going to make sure that all the parties who have an interest and a benefit from a working interest or an unleased mineral interest owner gets an opportunity to participate and be a part of the process. So we put together these well proposals. They include an AFE, the lands that we're going to be developing, the number of wells, the formations that the wells are targeting, anticipated timing, and what the party's interest may be. That's defined in the title opinion, whether they have a 5% interest in the unit, a 2%, or whatever that interest may be. And the parties have 60 days in order to evaluate this and get back to the operator. It's 60 days from the date of receipt. And we start to work through the mechanics of making an additional notice. This is, again, another touch point with those unleased owners where they have an opportunity to discuss and negotiate further an oil and gas lease. We oftentimes find that this later part of the process, and I'll mention this again later, this is when sometimes we get a little bit more engagement from these parties where they think, okay, I've got time to manage this. I'll get to that bill later, or whatever the case is. It's, okay, this is different than what I've received before. I still, in our notice, our well proposals, we still include that lease form letter and a copy of an oil and gas lease, and the opportunity for an unleased mineral interest owner to not only still execute a lease, but here we outline that they also have the opportunity to participate in the well with all of their interest, or they could elect to be non-consent and go through the statutory pooling process. So from here, we take that information after we've sent out these well proposals, we move on to the preparation to submit an application. And before I get to this, there's kind of an interim step here that I want to highlight, that there could be an instance where we may not need to go to the pooling process. Say we have everyone is entered into an oil and gas lease. All the parties are subject to a lease. All the working interest owners have said, we're in, we're party, we're ready to go. We may not need to go through this part of the process, and we may just go ahead and proceed with our development. However, there are instances where we have that 1% working interest party who may not consent. We move into this typical pooling process where we submit our application. So again, we lean on this title opinion. We take the list of owners that we've identified, the lands to be pooled for development. And again, a shout out to Mr. Peskin. Again, he highlighted this very clearly, and I thought it was a great presentation of all the information that goes into that pooling application. This is where that's all built. All that information we accumulate here and we submit that. And so from here, we move into step 4, which would be our notice and testimony portion. I know Paul is going to jump in on a piece of this. I'm going to kind of touch on the notice portion first, in that this is where, when we submit our application, we provide that list of all the parties who are working interest owners and the unleased mineral interest owners. And I belabor that because those are multiple touch points, but this is the first time in which royalty interest owners as well receive notice of our intent to pool this interest. And so we have this large list of owners that we've accumulated from our title opinion who receive notice of our intent to pool. And again, this notice from the list that we provide that goes out to all these parties is another opportunity for us to engage in pooling. And kind of to close this loop on all these touch points, sometimes this is the first opportunity that an operator, in my opinion, that we have sometimes with unleased parties. I am guilty of getting mail that I throw away and never even open. I'm also very guilty of not answering a phone number if I don't know who it is. I'm going to wait for that voicemail. And there are parties who have called us and have written back to us in an email and said, this is the first I've even heard of this. And I saw some stuff before come that we didn't really read. We didn't, we thought it was just junk. We just threw it away. Then we get this final pooling notification, and they take the time and actually see what's going on, and they reach out to us. And this is great because it's that last opportunity to engage with them and try to discuss, would you be interested in an oil and gas lease? What can we do to further this negotiation? If it's a party we've already been discussing and maybe they had some questions about how does this process work? Again, hearing some of the earlier commentary, it can be a confusing process if you're not familiar with how your minerals work and what your rights are. So it's great from this notice standpoint. It's that last touch point we need to kind of help close the circle.
Yeah, and I think that, as I referenced on the previous slide, where after we've submitted our application, there's a period of time where we're resolving disputes. I think that on the pooling side of things, taking a step back, it can be referred to as forced pooling, and I don't think that is accurate. I mean, how we refer to it is statutory pooling. And my experience with PDC is overwhelmingly positive in this step. We're looking for all of those interested parties to come together. We're looking to resolve anything that is at issue. And I think we've shown a very good track record, and obviously we want to continue that going forward. It's something that we try and be proactive with, obviously utilizing the COGCC brochure regarding pooling, which is available in multiple languages, but we also employ contract resources that are bilingual. So if we to engage with a community that doesn't speak English, or that isn't their primary language, then we're able to work through questions and get them engaged. Engagement is ultimately what we want. Exclusion is not. And this process, even though there's really not a detailed bullet point there, it is worth mentioning that is where not only the land team, but a lot of PDC works to try to bring all those pieces together to ultimately a step 5.
And that's a great point. And the thing that I would say there before we move to that step 5 is that engagement piece that Paul talks about is when we're working through providing my brain keeps wanting to say 511. It's a 505 testimony that as we build this and we submit this document to the commission, that within it, we're highlighting who we still see as an unleased party, or a party that's unlocatable. We've done everything we can to try to locate them, and they're still going to be an unleased party or a party who didn't elect to participate. This would be when we highlight these individuals as those that would be subject to the cost recovery. But it's important for that engagement that we are still going to be actively working with that party who may be still interested in trying to sign a lease, or they're negotiating maybe with another operator. That's fine. We want that engagement of that mineral owner to be part of the process and to have that opportunity to enter into an oil and gas lease prior to moving to step 5, where staff is reviewing everything. They're following up with additional questions as needed and clarity, and hopefully eventual recommendation that a pooling order is rendered. And really it's that timing when the order is effective. That date would be at which point we'd that would close the process, that bookends where we'd be trying to finish finalizing that lease. It's not a definitive. We've still had, plus or minus some days here and there where we've got a party that we're just, it's a hang up of sending a document back and forth. We're still trying to collaborate with them and get them engaged and wrap up the process. But that kind of walks us through how we get from spacing through our piece of putting the nuts and bolts together of the title to engage all of the parties to the end of the pooling process.
And I think if we were to not receive any questions, I think that would be an indication of our incredible failure. So we wanted to try to preempt some of the topics or questions that may come up, and really moving into the Q&A portion. So welcome any comments, questions whatsoever. So what do we do if an owner is unlocatable, which is a very common thing? We exhaust our search with online tools. We place ads in local newspapers. We've got people that will try to reach out to last known contacts. How do we accommodate non-English speaking populations? Again, we have the COGCC information, which is available in multiple languages, but we also employ some contract resources that can engage with those folks. How do spacing and pooling notifications differ? Spacing, again, is for those working interest and unleased mineral interest owners, whereas the pooling notifications go to the full spectrum of owners associated with those lands. Unleased mineral owners, what options do they have? They can sign a lease and receive typically an upfront bonus payment, and then if a well is drilled, their proportionate share in form of a royalty. They can sign a lease with PDC. They could sign a lease with a third party. That's absolutely something that's a decision point for them. They can also participate in the well and pay their proportionate share of the cost and receive their proportionate share of the revenue. If this is a 1 acre tract in a 1,000-acre unit, obviously they have a very small portion of a very large AFE, but they receive that and pay that proportionately. And then the statutory pooled terms is 16% for oil, 13% for gas. And then the operator is allowed to recover 200% of the drilling and completion costs associated with those wells. And then that owner begins to receive their proportionate share of revenue. And then what is the process with leasing with PDC? We have a standardized form. We have a standardized letter that summarizes the terms of that lease. It is open and transparent. We've got a bonus, we've got a term of the lease, we've got a royalty, and then obviously standardized provisions that are customary with an oil and gas lease. We've got a team of people that reach out to them, phone calls, emails, all of the above. I think we even reached somebody through Facebook or Facebook chat last year, which I kind of chuckled at. And then well proposals, again, transparent, all of the information associated with those wells, the cost estimate on a gross basis, the cost estimate on a net basis, and everything associated with those wells so that they can make a decision. So with that, I will open it up to any comments from my teammates or questions from the commissioners.
Thank you very much for the presentation. It's always great to sort of see it, see these rules and regulations on a more of an as-applied basis and how one operator might do it. And knowing your PDC and this is your approach, do you have any perspective? I mean, is what you outlined to us what we would see if a different operator came in and sort of, explained their sort of approach? Are there some commonalities here?
Yes, I think there is. Obviously, there are different business models that exist. I believe it was Mr. Peskin that had referenced that there are business models out there that all they want to do is be a non-operator. PDC is in the business of drilling, completing, producing, operating oil and gas wells. There may be somebody that doesn't have that as their core competency. And And I think generally, yes, the activity from my experience, and I've worked Wattenberg and Peon Basin and even some Eastern Colorado Yuma County stuff. And overwhelmingly, that's the experience, is that if you own an oil and gas lease, you're generally interested in seeing that developed, realizing the benefit of that development, and ultimately they have to make those own individual business decisions.
Thank you for that. Other questions from commissioners? Commissioner Nanjapa?
Thank you, Mr. Chair, and thank you very much for the presentation. This is really helpful, as Chair Robbins said, to get the perspective from you all. And I think you generally answered some of this, but I was wondering if you could dive a little more deeply into the efforts that are taken to locate those non-responding owners and to obtain their consent. And in particular, do you sort of make a determination on whether they are not locatable or just non-responsive? And I think, you were mentioning reaching out in various ways, including Facebook or whatever. So I was just kind of curious, like, to the extent you take that to try to determine whether they're, not there or just not responding. And then I have another follow-up question, but I'll stop there for now.
Thank you, Commissioner. Yeah, it's a great question. And thanks for stopping, because I'd lose track after one question. So it's I like to, again, think back to it, that it's an ongoing process. And, we start at one point and it's running this long race slowly to try to get this mineral owner on board with us. And they can't get on board if we can't find them, right? So if you think back to, and I would fail this trivia, I don't know how old when statehood, the date for Colorado was, because I was born in Oklahoma, but you have 100+ years of mineral ownership in this state. And you may have a party that I referenced, like 1960, this party kind of falls off the legal records. We don't see anything for decades. And it's hard to unpack, where did that person go? Where did their interest go? And so Paul kind of mentioned this, that we're going to use other resources as necessary. We're starting with that title. That's that record information in Weld County. And, this particular case for us, we're going to go see what's in Weld County in the recorder's office. We're going to go search the court clerk's records to see if there's probate documents or other kind of legal transactions that might help us get to who's the next party, or how do we find this person. We're going to look in, we've got online resources. A lot of folks have heard of LexisNexis is one that's commonly utilized, where we're going to use that online resource to try to track down folks, try to use next of kin. I used a reference earlier about two sisters, where we may get in touch with one and the other one's estranged, and we haven't been able to get in contact with her. And the other sister finally sees on our pooling application that the sister's listed and says, "Hey, we don't really talk to her anymore. She moved to, Alaska, and here's her new address." So we're using siblings, we're using next of kin, we're using neighbors. We've got, we use our broker staff or contractors who may go up to, a particular section and say, "Hey, do you know who owns the 20 acres down to the south? I know they don't have a homestead here, but do you know how to contact them?" So we're using multiple resources. And again, Paul mentioned even like Facebook nowadays, of how do we try to bridge that gap and use all these different tools to try to find somebody.
Yeah. And also important to note, Commissioner, is that our pooling application is not the end of our effort to locate these owners. So if a well is drilled and is producing, we've got a group internally within PDC, and that's called division orders. And division orders are the people that set up the decks and the percentage of revenue or royalty that will be distributed associated with the production of those wells. They are responsible for maintenance of those decks. So if somebody conveys their minerals, if somebody passes away, if there's an interest that is unlocatable, that interest is held in suspense. And it may not be as proactive to go and seek out those owners once we get further into the production period of a well, but it's not lost. It's not lost. And often what you'll see is when revenue begins to be distributed, you'll see another wave of those unlocated owners maybe bubble up.
Thank you so much. That's really helpful. And that's actually a great segue to my next question, which was, when, especially in the instance of somebody passing and there's, the mineral interest is, maybe it wasn't specifically bequeathed, to next of kin, or if it was, does that new owner of that mineral right, are they able to decide to participate or to become non-consenting? So can that change in the middle of the process?
Generally, no. So if an interest has consented to the well, then they've paid their proportionate share, they're receiving their proportionate share of the revenue. If the well hasn't been drilled, obviously on a case-by-case basis, we can revisit what the circumstances of that request is. Does that help?
Yeah, I think so. I wasn't sure if that was, if we had anything specific in our statutes on that type of thing with respect to transfers of ownership. And then the second part of that question is, you mentioned as royalties are coming out and people are maybe come out of the woodwork. What about in that, I think what I understand to be the payout phase, where now they are considered to be fully participating, and so therefore are also subject to bills that may arise. How do you deal with that with non-locatable or unlocatable owners?
Yes, so that is a risk that we identify as a land team ahead. And typically these unlocatable owners are very small, right? So it's not a majority of the unit. It's not really even a lion's share of the unit. So those interests are held in suspense. So if we were to get past the payout phase, then those revenues are ultimately held in suspense, and those JIBs, those bills associated with the ongoing operation of the wells, are also held in suspense. From an accounting perspective, I'm probably not doing it justice, but that's generally what's occurring. Yeah.
Commissioner Gonzalez.
Thank you, Mr. Chair. I just wanted to follow up on that real quick. I think Commissioner Njapa's question was specifically to unlocatable owners at the payout phase. Could you walk us through what happens to an owner who has been located, who has been receiving their revenues through the pooled royalty, and what it looks like when payout occurs and they are no longer an unleased working, when they are no longer a pooled interest owner?
Yes.
Pooled owner.
There's an owner that is statutorily pooled. PDC is recouping 200% of their proportionate share of the cost associated with the well. Once we reach that payout date, which depends on the well and commodity price, it's years down the line. But once we reach that payout, they then are not subject to a recoupment by the operator, and they are a heads-up working interest owner in those wells. They receive a JIB, an invoice for the cost of operating the wells, as well as their share of the revenue associated with the well.
Do they receive any notice when that happens?
I believe so. Tyler, help me out. Do you know?
We would have to confirm with our division order group, Commissioner Gonzalez, to be sure, but I believe that yes, they do receive that notice. And I would also add that there's oftentimes parties that are in this specific situation will reach out to us in order to execute a lease as they reach payout, so that they are then covered by that lease contract following their payout status to avoid their obligation for costs. Or they may have signed a lease with another party prior to that payout step. But we can check into that and let you know.
And that's fair, because mechanically within our company, accounting is tracking payout. And then once payout occurs, there's a deck change that our division order group will maintenance. And then I think Tyler's exactly right. That's when a notification would occur with that owner.
Sorry, Commissioner McGowan, and then Commissioner Nanjapa.
I have two questions that are completely unrelated. And the first is, do you ever have unleased owners who decide that they don't, it's just not worth, it seems too complicated, or they don't want the responsibility to enter into a lease or be forced into pooling? And do they want you, do you offer to purchase the minerals from them sometimes, just outright? Okay.
Yeah, that can occur. That's one option. It's not a part of our business model, so we're not out there looking to purchase up minerals, especially the small minerals. Those transactions have, you know, an administrative responsibility internally that is just not our focus. But yeah, that is one of the options, I suppose.
Okay, and I don't know if you all can answer this question. This might be for staff. Is it possible for more than one application for a spacing unit to be approved for the same space by the commission? Like nothing really, so can more than one owner apply for a spacing application for the same geographic area, and can they both have been approved by the commission?
I don't think so, but I hesitate because I worry about what I'm not thinking about. Obviously, if it were for different formations, it technically could. But if we were talking about a Codell or a Niobrara well covering the same plan and really just kind of overlapping duplicative developments, I don't believe that would be the case, but I absolutely could be wrong.
I would also look to AAG Davenport perhaps for some legal advice on that question.
Thank you, Mr. Chair. And I saw Commissioner Gonzalez with his hand up as well. If he wants to chime in, happy to let him go first.
Sure. So I lost my train of thought when you got called on, Kyle. Could you repeat the question one more time, Commissioner McGowan? I had a thought that I do want to chime in with.
So for a spacing application,
I recall now.
Okay.
So can two operators operate the same spacing unit or apply for the same spacing unit? And I don't know the specific answer to that, but I think the question I want to turn back to the panelists here and to staff is a spacing unit operator specific? It's my understanding the spacing unit itself is only bounded by a geographic area and a density associated with it, in which case any number of operators could permit wells within that spacing unit so long as the spacing unit is adhered to and the density of the wells within that spacing unit is in conformance with the orders.
AAG Davenport.
Thank you, Mr. Chair. The short answer to your question, Commissioner McGowan, is no. We can't have spacing units that, you know, are basically the same spacing unit approved in two different orders. Spacing units can overlap in the sense that I think you may have seen under the prior rules, the 318A wellbore spacing units, which boundaries can overlap. And we will still, I presume, have boundary wells that have individual well spacing units that may overlap with the larger spacing unit. That, I think, is a little different from what your question was. Another part of your question, as I understood it, was yes, two operators can apply for spacing units that intersect, in which case, for example, you may have an operator apply for what the vernacular is a stand-up 1280, two sections north-south, and another operator will apply for a lay-down 1280, and that section in the corner overlaps. The commission cannot and does not approve both of those spacing units. If those are what we've referred to in the past as competing spacing units, the commission will need to approve one or the other.
Sure.
Director Murphy.
Thanks. I may follow up just a little bit to say that as both Commissioner Gonzalez and Kyle noted, spacing applies to a single set of minerals. And then the pooling order follows that spacing unit designation, but a spacing unit doesn't designate operatorship, so you could have multiple operators within the same unit. I would have to go back and look and might need help from Mr. Peskin to think about whether once a unit is pooled, it's pooled for all operators, or whether because it requires individual engagement, if it would be operator specific. But I've always thought that once a unit is pooled, it's pooled. And so long as whoever's operating with it complies with the terms of both the spacing unit, and again, you could space multiple formations. So the same acreage might have multiple spacing units stacked on it, but they apply to different formations. And then you can have multiple operators within that space. So it is good to think about both the geology and the spacing as a layer cake. That to me has been the most convincing visual when I'm thinking about subsurface oil and gas development. And then spacing applies to each of those layers or some of those layers. With the DJ orders, we're used to thinking about the Niobrara and Codell as the two layers that we often see together. And in some places, they almost become the same formation. And I should stop talking and call Jane in if you want to have any further discussion about those layers. But that's my kind of high level input, somewhat unsolicited, but I thought I'd jump in.
Anybody else with input to this question? Commissioner Najapa, I think you were next.
Thank you, Mr. Chair. And I actually just had a quick follow-up on this topic, which is maybe really elementary, but I just want to make sure that I'm fully understanding. So once the spacing unit has been determined, and then a pooling application goes in, is it basically that as long as you've got 45% of the mineral rights ownership, or the consent, is it the consent of the 45%? And then, and so maybe your consent is actually more like, say, 60%, then are all the other 40% considered non-consenting if they did not elect to participate? Does that make sense? I'm just trying to see, like, is it that, you've got consenting and non-consenting, and that total comes to 100%, regardless of how much is actually your ownership. Does that make sense? Or your right?
Yes, I believe I understand the question, Commissioner, that yes, we have, if we've met our 45% threshold of consenting, or in most cases, PDC as an operator, we're going to have, we're bringing more than our 45% to the table that we're participating with. And we may have that outstanding, say 10% that's owned by company X who doesn't want to participate. They don't want the cost exposure. That would then be separate from and get us to that total. If we have 90% of a unit and then they have that 10, that brings us to that 100% total that would be all included within our pooling application. I think I'm
okay.
tracking.
Yeah, and I guess what I'm getting at is that the pooling application pertains to the entire spacing unit. Is that correct? And so you're pooling everything there, and you have some owners who are consenting and some who are not.
That's correct. We're pooling all of the mineral interest associated with the lands within the spacing unit, and you have the right to participate or not and be non-consenting as you have your interest within that spacing unit, and then would be subject to that pooling order. Yes.
And
okay, thank you. And then, oh, sorry, go ahead.
I was going to say one thing to add to is, as I think it was on the first or second slide, PDC has roughly 180,000 net acres in the Wattenberg field. That is 180,000 net of roughly 192,000 gross acres. So overwhelmingly, we have, the 90+% of the leasehold in the units that we are moving through the system, through the spacing and pooling process. So we don't encounter where we're the minority owner in terms of percentage and we're dragging people along. And one thing to note too is the non-consent aspect of a well, in our experience, is driven by we're not going to allocate an investment into those wells, therefore we non-consent, versus we don't consent to this well being drilled at all, right?
Yes, actually, and again, that's a great segue to the original question that I had, which is with the participating owners or the consenting owners, do the terms of those agreements, is that, with the sort of, I think the language is intangible costs. Can that sometimes include things like plugging and abandonment, reclamation, other aspects, or maybe even bonding or other aspects like that? What are typical terms?
So if we have a consenting working interest owner, they are essentially in the same boat as PDC. Everybody's paying their fair share of the cost to drill, to complete, to produce, to plug, to remediate, to reclaim. All of those are a part of consenting to that well. And that's not a one-year decision, right? These are wells that produce for 10, 20 years. And so that is the consent that those people are making, the business decision that they're making. In terms of bonding, yes, they pay their proportionate share of bonding, but PDC also carries its own bonds as the operator, and strictly speaking, related to the costs associated with a well, everybody pays their proportionate share once they've consented.
Okay, so thank you. So the consent is basically from cradle to grave for the operations. Okay, all right, thank you very much.
Generally, yes, absolutely.
Commissioner Messner.
Thank you, Mr. Chair, and thank you for the presentation. I thought it was really well done. I've got a couple of more abstract questions, but so I mean, the understanding why spacing and pooling was created, I mean, to me that's logical. I think directional drilling and now horizontal drilling has certainly changed the dynamic of what pooling is. What's some technologies that you guys foresee into the future that may, again, change the dynamic of pooling and spacing, as you look in the into the future?
On record predictions. This is we got to be careful here. Let me tee up. I think Dana, the question during Mr. Peskin's presentation regarding, I think it was regarding the number of applications, and there was one of the first slides, and Courtney, maybe you can just scroll back to, I think it was slide 2, where we show the units. There we go. So less than 10 years ago, a 1 mile long horizontal well was the norm. In fact, that was aggressive, right? That was new technology. And if you look at that map in the lower left, you've got 8 sections. And so we would have 8 developments associated with those sections. Now, technology has allowed us to lengthen those laterals, has allowed us to consolidate development, which has, obviously less pooling and spacing applications, but also less surface impact, which is something that's beneficial to us, right? We're financially motivated to consolidate as well. And so in terms of future predictions, I'm gonna hand that one off to Dana.
No, I appreciate that, Paul. You can be on my team anytime. But yeah, and I guess there was also a question during the staff presentations about vacating spacing and then applying for a new one, so changing your plans. So what I talk about is kind of what happened in the last few years and how that's probably going to continue. And I think in my mind, you've got drilling. So as Paul mentioned, we used to drill just 1 mile laterals. It was just one well in a section. Now we have multiple wells in a section. We can do longer kickouts, so we can go. We can have a surface location in one area and kick out about a mile, and then 2 miles underground. We've drilled some 3 mile laterals. I know there's other companies in other basins that are pushing the 4 mile mark. So I would say on the drilling side, you're going to continue to see longer laterals. On the completion end, there's always increases in technology there where you can increase your drainage radius. You can, there's got to be technology to be able to complete the third and fourth mile of those laterals that the drillers can then drill. So there's a lot of technology improvements there that we're looking at now. But I guess that kind of answers questions of when we have original spacing units, we might have that just one section spacing unit, and then we see that we can have 2 or 3 sections included. So that's when we would go in and ask for to vacate the previous unit, come on with a new one. That also happens with trades. I hesitated a little bit on jumping in on the previous question, but a lot of times we're trying to avoid any sort of protests on a public level. So we're constantly talking to our non-operated partners and the different operators in the basin. Contrary to popular belief, we all are friends and we like to work together. So we're oftentimes trying to create those smaller trades that we are out of each other's hair, as we like to call it, and develop our own minerals in our own ways. Because as you can see with the different applications, some of us have different spacing philosophies in terms of how we drill and develop how many wells per section. There's no right or wrong answer there. It just kind of depends on your business models and how you want to drain the acreage. So that was kind of a long-winded answer, but I would say drilling, completion, and development style are kind of the 3 things that we look at, and we're constantly on the engineering and geology side trying to understand how best to drain the reservoir in a thoughtful and efficient manner.
Thank
Great.
you.
Thank you.
Did you have a follow-up, Commissioner Messner?
No, I was just curious.
I guess I'm kind of curious, and I'm not sure who to send this question to, but obviously we've turned on the new 181 regulatory regime as of January 15th or 18th, and new forms are available. We have, the new OGDP process, which is sort of that one permit process. We also have available to companies, your company may take advantage of it, the comprehensive area plan. Looking forward, how does sort of pooling and spacing play into sort of if you're thinking about doing a comprehensive area plan? Does it change? Are there opportunities we need to be thinking about? I don't know, it's kind of an open-ended question, but I do want the new regime to work. And are you seeing things where we need to be thinking about this differently, or you as an operator under the comprehensive area plan or under a large OGDP?
Perhaps I can start on that one, and then we can jump in, unless Courtney, you haven't heard from me.
I was going to say Dana is our CAP lead, so you've got the right expert in the room.
Yes, I think that is a fantastic question, and it's something that I need to think about a little more on how spacing relates to OGDPs and CAPs. But what I can say is what I was trying to articulate in the beginning is that PDC as a company has really tried to evolve into that OGDP and CAP concept before it was even an OGDP and CAP concept at the commission and COGCC level. We were coming in, trying to come into an area, develop that entire acreage as fast as quickly as possible, get in, get out, develop our minerals, limit our surface impact, reclaim all of the vertical wells that are there so that we can go in and be efficient on the operator side and also be efficient with the community. So I would say that the concept of OGDPs and CAPs is something that we're very excited about, that we're ready to roll out as soon as possible. And as soon as the forms are ready, we've got a plan in place, we've got project teams in place, we're ready to roll on that end. That slight nuance of your question on how spacing is related, my initial thoughts would be on the OGDP side, you'd be grouping that spacing in with your OGDP application. So I would assume that your spacing would follow along with your entire OGDP. And then when we're thinking about CAPs, the CAP itself would be approval of our preliminary siting, right? And then after we get that approval, we'd be able to submit individual OGDPs, which will have their individual spacing associated with them. So that's my general thoughts on that. I don't know, Courtney, if you have anything to add there.
No, I think that's exactly right, Dana. I think the beauty of the cap is that it allows us that freedom to get, that consolidated acreage, that best acreage. And so I think, when you ask the question, Commissioner Messner, about what technology do we see as the future, I think, that remains to be seen. And if we could answer that question, I'd have a show on, on TV. But I think that for us, we really see the OGDP and the cap process as the future, right? It is a different way of looking at things. And I do think that it's going to be the model for operations. And so when you're taking this big picture look at it, certainly spacing and pooling is a small part of it, but we really are looking at this collaborative process between the regulatory side of things, the operations side of things, and the community side of things as the future of where our operations are going.
Trying to find my mute button. Thank you both for those answers to that sort of open-ended question. I appreciate that. Other questions from commissioners? This has been highly educational, and I really want to thank you for the presentation. I personally would love to be able to look at the slides on my own time. So if you can share that, we can get that to commissioners. It's helpful for us as we initiate engagement into being the permitting entity to have a more thorough scale understanding of the work that goes into these processes before it shows up, on a docket. And so that, I think, has been very helpful.
We certainly will. And I'll reiterate, thank you so much for the time. I think the key points that we wanted to reiterate to you are that this really is a collaborative process. This really is, you heard the word notification and borderline stalking. I think that, we really want this to be transparent. We really want this to be a dialogue. And I think that, to your earlier question of, is this the case for every operator? Certainly can't speak to that, but we'd hope so, right? We all in this industry want this to be a two-way street. And so we welcome the opportunity to engage with folks and to have this conversation. And we welcome the opportunity to have it to you or with you. And if there are any subsequent questions that arise from this, please don't hesitate to reach out to us. We are an open book and we're always available.
Thank you, Ms. Loper. And I also want to thank Commissioner Gonzalez for putting together today's educational foray into spacing and pooling. Great job there at getting the various stakeholders from our group to PDC today as well. Any further final questions from commissioners? All right, I'm not seeing any hands go up. So again, thanks very much.
Thank you very much. Really appreciate the opportunity.
Excellent.
Thank you.
Yeah.
Thank you.
All right. That brings us to the commissioner comment section of our agenda. Do commissioners have comments? I would note that we did have one, I believe, recommended order. And again, we don't need to do anything and it will become effective, but just reminder that that is on our agenda for commissioners. My screen's going all over the place as people are leaving. Commissioner Gonzalez, hi.
Hi, I just have a quick comment on these informational dockets in general. And I just wanted to say thank you so much to Ms. Stanzik and Mr. Peskin for the work that they put into the presentation that they provided today, as well as to PDC Energy for being willing to step up and really kind of pull back the curtain and let us know what it looks like from the operator perspective. I think this has been truly helpful, including to myself, and I appreciate all the questions from my fellow commissioners that were asked today, and just a great step towards continuing to develop our knowledge and to help us do better at doing our jobs. So, so a big thanks to all the presenters today. In future informational dockets, we may be asking for volunteers to come in and share their perspective. So keep an ear out for that in these hearings. And we look forward to hearing from more operators on various topics as we go forward.
Thank you, Commissioner Gonzalez. Commissioner Najapa.
Thank you, Mr. Chair. And yes, I just wanted to also just echo the thanks to the staff and to PDC for presenting, and to Commissioner Gonzalez for the legwork that went into it. The other thing I just wanted to note is some of the public comments that we received this morning. Really appreciated the time that people took, and also just wanted to remind everybody, if they're still listening, that policy processes are really long, and we just got to implementing these new rules. So it may feel like nothing is happening, but please bear with us, stick with us, keep us aware of things you're concerned about. And, we are listening. We are looking to see how well the new rules are going to work. And just want to keep hearing your comments as we go forward. But just remember that we've just barely started with the new rules. So thank you.
Good point, Commissioner Najapa. Commissioner Hackett. Yes.
Thank you, Mr. Chair. I just had a couple comments about some goings on over at CDPHE. Just wanted to let folks know that we're hoping to meet with COGCC staff soon to talk about a joint hearing, possibly maybe sometime in March, a joint Air Quality Control Commission and COGCC hearing. We're still working out the specifics about the scope and content of that and the timing of that. And also just wanted to make sure you are aware, this is separate but related, and maybe we'll punt this to the joint hearing. But I've exchanged some emails with Ms. Amaro, and we've tentatively identified the February 24th COGCC Commission as potentially an opportunity for the Air Pollution Control Division to provide an update on the Oxy settlement projects. But one thing we'll be discussing is whether or not to just postpone that discussion until the joint hearing in March. Another thing to keep in mind, February 18th, the Air Quality Control Commission will be holding a hearing on minimizing emissions from pneumatic controllers. That is part of their efforts to implement Senate Bill 181, among other objectives. And then the other thing that I wanted to mention, the last thing, I'm sure you all saw that on January 14th, Governor Polis released the Colorado Greenhouse Gas Pollution Reduction Roadmap. That roadmap is a momentous step towards realizing Colorado's ambitious yet achievable goals to attain 100% renewable energy by 2040, as well as our mandates under Senate Bill 181 and the greenhouse gas emission reduction targets under House Bill 1261. There is right now on the Air Commission's calendar, their most recent calendar. Again, this is going to be an economy-wide effort in order for us to meet these greenhouse gas reduction goals, and the oil and gas industry will play a big part of that. Right now, the current plan is to take this up sector by sector. The transportation sector piece, the rulemaking request, I believe will be in April, and the actual hearing will be in July. And the oil and gas sector piece of the rulemaking efforts there, I believe will be requested in September with an actual hearing December. So just wanted to share that information with you all.
Thank you, Commissioner Hackett. Appreciate your bringing the CDPHE perspective to our table. Other comments from commissioners? All right, well, thank you all. We still have 65 participants. Thank you all for your participation. We meet again next Wednesday, I believe, and we will look forward to that. At this time, I believe our agenda is complete, and we would look for a motion to adjourn.
So moved.
Second.
All right, we have a motion and a second. All those in favor of adjournment, please signify by saying aye. Aye. Any opposed? Looks like we're adjourned. Thank you, everybody. We will let everybody get back to their daily business. Talk to you soon.